This is an appeal in the matter of Nazir and Anova and Begum.
My Lords, I appear for the appellants, Mr. Kaiser Nazir and Mr. Naeem Nazir, under the auspices of Advocates Court of Appeal scheme. Mr. Kaiser Nazir is here today. Mr. Naeem Nazir was unable to attend. I also have with me Chambers pupil Helen Bunce. My learned friend Mr. Roberts appears for the first respondent, Ms. Begum, in place of Kate Sweeney, who is unable to appear today. Lords, this is an appeal on 2 points of law, so the facts can be dealt with quite briefly. It concerns a plot of land of which my client's father, the late Mohammed Nazir, was the registered proprietor. The land falls between the late Mr. Nazir's house at 37 Lower Rushton Road and a house at 1 Gerbach's Court, of which Mr. Mohammed Perwez was the registered proprietor. My client's father, Mohammed Nazir, died intestate in 2010, and my clients were granted letters of administration in 2019. Mr. Perwez then died in 2020. His widow, the respondent, was registered as freehold proprietor of 1 Gerbach's Court in 2021, so she's the successor entitled to Mr. Perwez. And my clients, as their father's administrators, issued a claim for possession of the disputed land on the 1st of February 2022. And the particulars of claim in that claim stated, this property is under probate administration, hence we need to reclaim this property from defendants who are trespassing on our property. I won't go to it, but the reference is paragraph 4 of the particulars of claim, tab 20, page 180. The respondent filed a defence on the basis of adverse possession. My clients filed a reply in which they repeated that the land was under probate administration. Paragraph 2 of the reply, tab 22, page 191. And at the trial, His Honour Judge Walsh dismissed the claim on the basis that there had been adverse possession for 10 years and a reasonable mistake as to the boundary. My clients, who represented themselves at all stages below, applied for permission to appeal from the County Court on the basis, among other things, that the land was under administration and so could not have been in adverse possession as a matter of law. As your Lordships know, Mr. Justice Sweeting granted permission to appeal on that point, and the appeal was dismissed by Mr. Justice Freedman, and permission to appeal to this court was granted last year by Lord Justice Stuart Smith. So those are the facts. I was going to turn next to the Land Registration Act 2002 to explain the statutory context in which this all arises. So that's the authorities bundle, tab 5. If I could ask your Lordship to go to page 40.
So tab 5.
Tab 5, page 40. So this is part 9 of the Land Registration Act 2002, which deals with adverse possession. And section 96(1) there says no period of limitation under section 15 of the Limitation Act shall run against any person other than a chargee in relation to an estate in land or rent charge, the title to which is registered. So what 96(1) does is switch off adverse possession as it usually works in unregistered land. So it's switched off there. Then section 97 tells us that we have to look at Schedule 6 for provisions about the registration of adverse possessors. And then section 98, defences. This is the defence that was relied on by the respondent at the trial of the claim, and it requires 2 things to be shown. So in a defence to an action for possession of land, they have defence if on the day immediately preceding that on which the action was brought, so in this case the day immediately preceding was the 31st of January 2022, if on that day the respondent was entitled to make an application under paragraph 1 of Schedule 6 to be registered. That's condition A, as it were. And then condition B is that if the respondent had made such an application on that day, the condition in paragraph 5.4 of that schedule would have been satisfied. That's the boundary condition. So 10 years of adverse possession, broadly speaking, ending on the date before the application is brought, and then the boundary condition as well. I'll come to those in a moment. Section 98.5 is worth briefly looking at. If the court determines that someone's entitled to a defence, so 5A, then the court must order the registrar to register him as proprietor, and that's what happened in this case.
Yeah.
So then turning to Schedule 6, which is at page 45. This is the schedule dealing with registration of the adverse possessor, and 1.1 there, as we've just seen, someone has to satisfy this in order to have the defence. That's condition A of the defence. The person may apply to the registrar to be registered as the proprietor of a registered estate in land if he has been in adverse possession of the estate for the period of 10 years ending on the date of the application. So hence it's the 10 years ending on the date before the claim is brought. And then the next paragraph to go to is paragraph 11 of this schedule, because that tells us what adverse possession is. So 11.1, a person is in adverse possession of an estate in land for the purposes of this schedule if, but for section 96, a period of limitation under section 15 would run in his favour in relation to the estate. So we've seen that section 15 gets switched off to stop adverse possession happening automatically, but this in a sense brings it back in again to determine whether you are in adverse possession or not. So I'm not going to go to the Limitation Act now, but I'll go there later. It brings in various provisions of the Limitation Act. And then after that, there's paragraph 12, just over the page. A person is not to be regarded as being in adverse possession of an estate for the purposes of this schedule at any time when the estate is subject to a trust, unless the interest of each of the beneficiaries in the estate is an interest in possession. So in other words, even if there would be adverse possession under, for other reasons, there still isn't if it's subject to a trust, unless everyone has an interest in possession. So those were the provisions that I was going to look at. I skipped over 5.4. Should we just go back to that? Paragraph 5.4 on page 46 of the bundle. I don't think we need to go through it in detail, but it's the boundary condition, which involves a 10-year period as well, but it can be a different 10-year period. I don't think anything turns on that.
I'm sure I'm missing something, but why? So there are 4 different conditions that can be complied with in order to establish a right to be registered under paragraph 5.
Yes.
Why is it that only the 4th one operates as a defence under section 98.1?
Under paragraph 5, I think there are 3 conditions,
Yes.
and I think I have to say that I don't know. My speculation would be that the first 2, equity by estoppel and some other reason entitled to be registered, in those cases you do have another remedy, basically. You can, if you're entitled to be registered for some other reason, you can presumably get registered through that right. And if you're entitled to proprietary estoppel, that might be it, but I'm afraid that's speculation on my part.
Mm-hmm.
So that's the statutory context. The structure of my submissions, I'm going to deal with subject to a trust first, and then more briefly with interest in possession. Under the heading subject to a trust, I have 7 submissions to make on that point. I'll run through those very briefly now, and then I'll develop them in turn. So the first submission is that statute provides that land held by personal representatives is held subject to a trust. So the statutory point. Then second, even outside statute, land held by personal representatives is recognised to be held in trust. Third, the interpretation that I put forward, i.e. that trust includes an unadministered estate, creates a consistent and coherent statutory scheme for adverse possession of registered land across the two statutes, namely the 2002 Act and the Limitation Act 1980, which make provision about it. Then fourth, there's nothing in the language of the rest of paragraph 12 to indicate an intention to exclude unadministered estates, contrary to the reasoning of the learned judge below. Then fifth, the pre-legislative materials, if they're read properly, indicate that paragraph 12 was intended to include all trusts of land and therefore to include unadministered estates. Sixth, the respondent's interpretation, I say, leads to anomalous results, particularly in relation to settled estates. And seventh and finally, the word trust here should be interpreted consistently with its meaning elsewhere in the 2002 Act. So I'll develop those in turn, and then at the end I'll look at the judgment again to explain why, in light of those 7 points, the judgment is in error on what subject to a trust means. And after that I'll go to interest in possession, which I don't expect will take so long. So my first submission then, statute provides that land held by PRs is held subject to a trust. I rely on two statutory provisions here. The first is the Administration of Estates Act 1925, section 33(1), and that's in the Authorities Bundle, tab 1, page 4. And if I could go to that now. So section 33, subsection 1, on the death of a person intestate, as to any real or personal estate, that estate shall be held in trust by his personal representatives with the power to sell it. One point to note about this is that although it talks about the death of a person intestate, by subsection 7 it's extended to testate estates, except insofar as the will provides otherwise. So we're talking about both. Of course, this case is an intestate estate anyway.
It can't be literally true, can it? Or it can't be taken at face value, because on the death there will be no personal representatives and the person who died intestate will.
That is true. There can be relation back, of course, for administration where you have an administrator under both common law and some statutory provisions. The grant of administration can relate back, and so in that extended sense it is true. So I think perhaps what one should read it as saying is that on the death of a person intestate, brackets, as soon as the grant has been issued, the estate shall be held in trust by his personal representatives. Of course, because of subsection 7, it applies to testate estates as well, and the land or the property vests in the executor at death before the grant of probate. So it does apply literally where there's an executor appointed by will. And of course, actually intestacy, one can have partial intestacy. So I could make a will that simply says, I appoint my pupil Helen Bunce as my executor, and then says nothing about the disposition of my estate. I would die intestate as the distribution of my estate, but I would die with a personal representative. So I suppose in that case it would apply literally, even to well.
An unusual situation, that.
Yes, although partial intestacy is not that unusual if the will fails to make provision for a particular situation.
Situations,
Yeah. So yes, I accept it. One does have to read it with a bit of flexibility.
When it says in paragraph 1, held in trust,
Yes.
what does that mean?
It means the trusts imposed by statute and at common law or in equity on the personal representatives. In particular, it's the duties in this section here, the rest of this section, and in the rest of the Administration of Estates Act 1925 during the course of the administration. There are, of course, extra statutory equitable duties, but perhaps the most important is subsection 2, worth having a look at, and that's the duty to pay out of the deceased's ready money and the net proceeds of sale of their assets all the funeral, testamentary and administration expenses, debts and other liabilities that are properly payable out of their estate, having regard to rules of administration, and then out of the residue of that money to set aside a fund to provide for any pecuniary legacies bequeathed by the will. So that's, as it were, duty number 1 or trust number 1. Then other trusts, of course, within section 33(1, there's the power to sell, so that's part of the trusts. Then subsection 3, during the minority of beneficiary or the subsistence of a life interest and pending distribution of the whole or part of the estate, the PRs may invest the residue, or so much thereof has not been distributed, so they've got a power to invest. And then 4, what that tells us is that once they've done the steps listed above and they're ready to distribute, that's the residuary estate. And once they've ascertained that, of course, that's when the administration comes to an end and they hold either on the trusts of the will or, if you're intestate, on the trusts imposed by section 46 of the Administration of Estates Act, the statutory trusts as they're sometimes called.
I noticed that section 33 subsection 1 was actually substituted by Talata.
Yes.
Section 5 of Talata.
Yes.
Does one get anything at all from the rest of Talata that assists us with it?
That's my second statutory provision I'm going to rely on, so I'm just about to go to Talata.
What did the Act say? I mean, it may not matter historically what the Act provided between 1925 and 1996. Did it still use the words held in trust?
I think it was on trust for sale, because I think the exact language I could find if you would like to see it, because it's quoted in Earnshaw and Hartley, which I'll go to later.
Because one of the things that's said against you is, well, when it says held in trust, it doesn't really mean trust in the classic sense. It means effectively somebody with putting it broadly, who owes a fiduciary duty. I just wondered whether one got any assistance from the statutory history.
It certainly used the word trust, and the type of trust it used to impose was a trust for sale.
Trust for sale.
So the real change is that before 1996, the duty was to sell, and there was a power to postpone sale, as there was with co-owned land, broadly speaking. Whereas post 1996, there is no duty to sell; there's merely the power to sell. So I think that's the only real change. I don't think it particularly matters. So that's section 33, and actually I'll turn now to Talata, which is the next statutory provision I rely on. That's tab 4 of the authorities bundle, page 35. Section 1, meaning of trust of land, subsection 1. In this act, trust of land means, subject to 3, which we don't need to worry about, it means any trust of property which consists of or includes land. So, question, is the section 33(1) statutory trust a trust of property for these purposes? Answer, yes. Section 18 tells us that of Talata, so that's page 38. Application of part 1, which includes section 1, obviously, to personal representatives. Provisions of this part relating to trustees, other than sections we don't need to worry about, apply to PRs, but with appropriate modifications and without prejudice to their functions for the purposes of administration. And the appropriate modifications obviously include substituting persons interested in due administration for references to beneficiaries, and substituting the will for the dispositions creating the trust.
That shows that personal representatives are not trustees, doesn't it? It's just that the provisions of the Act will apply to them.
No, in my submission it shows that they are trustees because it's not a deeming provision. It doesn't say, for the purposes of this Act, personal representatives shall be treated as or regarded as trustees. It just says it is, I would say, a declaratory or clarificatory provision, because sometimes personal representatives, sometimes the word trust includes personal representatives and sometimes it does not. It depends on the statutory context.
It doesn't here, does it? But instead says the same provisions will apply to the personal representative.
No, so what it says here is the provisions relating to trustees apply to personal representatives. So that's confirming that they apply, rather than saying that there would be another way to draft it, which would be to say personal representatives for the purposes of this Act shall be regarded as trustees, and beneficiaries interested in the due administration shall be regarded as beneficiaries of the trust. That's not the drafting device that's been used here. And there's a good reason for that, which is that trust itself, depending on the statutory context, can include personal representatives. And the drafter, in my submission here, was aware that Section 33 used the words in trust. Indeed, it's been, as my Lord the Chancellor pointed out, the new version of Section 33(1) is actually enacted by another bit of Talata. So
Section 18 does suggest that they're not trustees, as it were, independently of the section. The section is saying that they're in effect they're to be deemed to be trustees or regarded as trustees. And if they were already trustees, irrespective of the section doesn't seem to be achieving much purpose.
well, if this section weren't here, then we could be having the same lively argument about whether personal representatives hold on a trust of land.
Well, you still have the same argument about Section 33, I agree.
Yes, so the drafter here has very sensibly realised that Section 1 would be ambiguous as to whether it included personal representatives or not, and so it's confirming or clarifying the ambiguity that would otherwise arise. That's a different thing from a deeming provision. In deeming provisions, we see them all the time and they use words like treated or regarded as. This is not a deeming provision. It is not the language that has been used.
So the purpose of Section 18 seems to be other than you're suggesting, because what it's saying is that the provisions other than Sections 10, 11 and 14. So if you were right, all it would need to say is Sections 10, 11 and 14 do not apply. If otherwise they would apply. What does Sections 10, 11 and 14 say? What
10, 11 and 14 are, I think, about the occupation of land. I would have to check that.
But they are other provisions of this part that relate to trustees and what trustees can and can't do.
Yes.
So that if the provisions applied automatically to PRs as trustees, then wouldn't this be differently phrased?
Differently.
I can see that another way of phrasing it would be in that way, but that wouldn't be such an apposite drafting device for then putting in the stuff about the appropriate modifications. Difficult to draft statute in one's head, but I think if it said simply Sections 10, 11 and 14 do not apply to trustees,
it wouldn't deal with the appropriate
it wouldn't deal with the
modifications.
appropriate modifications.
Yeah.
So this is, in my submission, a well-drafted section, because what it does is it recognises that there is a trust imposed by another provision on land held by personal representatives, therefore the land is held in trust, but it recognises that the type of trust that has been imposed by that other provision is in some ways different from the type of trust that applies on a narrow sense of the word trust. So this is good statutory draftsmanship. It's using words very precisely and appropriately. I accept there might be another way that it could have been expressed, but this way, I say, fits very well with my submissions.
And the other point is that this is obviously 1996, as my lord has said, the Administration of Estates Act dates from 1925, and section 18.3 says section 3.1 doesn't apply to PRs if the death occurs before the commencement of this act.
Yes.
So there was a long, long period of time during which this provision wouldn't help with the meaning of section 33 in terms of what it creates.
Well,
What was section 3?
the land would have been held on a trust for sale instead, rather than on a trust of land.
Yes, all I'm saying is that you're using section 18 for the purposes of interpreting a provision. I appreciate that section 33.1 was included within the Administration of States Act by the 1996 Act, but there was a long period before that during which the Administration of States Act had to operate.
Yes.
Absent this provision.
Yes, and at that time there were really two types of trust that could affect real property. There were trusts for sale and settled land act settlements. The trust of land didn't exist before 1996, and of course the Land Registration Act postdates it. So I might be missing something, but I'm not sure that there's a problem with the fact that with subsection 3.
Okay. Right.
So yes, I say the combined effect of the two statutory provisions we just looked at, 33 of the AEA and section 1 and 18 of Talata, the combined effect is that the land held by PRs is held in trust.
So just to be clear what your submission on the section then is, you say section 18.1 is there because the part, this act applies to PRs anyway because they are trustees. This is merely confirming what already exists.
Exactly so. That's exactly my submission. Because otherwise we'd have this argument about what section 1 of Talata meant. Fortunately, the drafter realised that that might be a problem and has clarified it. So yes, combined effect is that the land is held in trust. That trust is a trust of land, and that is the same type of trust as the trust on which ordinary trustees hold land, i.e. trust of land. So that's my first submission. My second submission is that even outside statute, land held by PRs is recognised to be held in trust, and that's the Livingston and Ayest cases. So starting with Livingston, that's tab 9 of the authorities bundle, page 86. So decision of the Privy Council, judgment of the board given by Lord Radcliffe. The facts of the case are worth just recalling. It's one of those cases more often cited than discussed in much depth. The facts were a husband and then a wife died in quite quick succession, Mr. and Mrs. Coulson. Each of the husband and wife had been domiciled in New South Wales, but the husband's estate included property in Queensland. The wife died second, and her estate, when she died, included a share of the husband's residuary estate. And on her death, the Queensland Tax Authority assessed her estate to succession duty on the basis that she had died with a, quote, beneficial interest in Queensland property that was in her husband's unadministered estate. And what the board held was that she didn't have a beneficial interest. She had a right to proper administration, but that wasn't a beneficial interest in the Queensland property. for the purposes of the tax that was under consideration. If I could ask your lordships to turn to page 108 of the bundle, which is 716 on the internal pagination. There's an important aspect of the reasoning that's explained here, which is that it was necessary to determine the situs of the wife's rights in respect of her husband's estate. So at 716, letter F, if I could just ask your lordships to read from where it says whereas here by letter F, down to the end of that paragraph, which is about halfway down the next page. So, in other words, the statutory context in the Livingston case called for a particularly strict legal analysis of the rights of a residuary legatee so as to determine whether the wife's estate had rights that were taxable in Queensland or not. One needed that strict analysis to see where the rights were situated. And against that background, if I could then ask your lordships to turn back to page 99 of the authorities bundle, internal page 707, and that this is the more well-known passage. So when she died, she had the interest of a residuary legatee. The nature of that interest has been conclusively defined, etc. And then, subject to the working of certain special rules, whatever property came to the executor virtute officii came to him in full ownership, without distinction between legal and equitable interests. The whole property was his. He held it for the purpose of carrying out the functions and duties of administration, not for his own benefit. These duties would be enforced upon him by the Court of Chancery. That's quite important, if application had to be made for that purpose. So he was in a fiduciary position with regard to the assets that came to him in right of his office. We might now say he's a custodial fiduciary, and for certain purposes, and in some aspects, he was treated by the court as a trustee, and then quotes a 19th century case about liability and equity for breach of the trusts that arise from the office. So it's a breach of trust liability if they breach, say, the section 33(1) trust. May not be possible to state exhaustively what the trusts are at any one moment. That's the answer to the question I was asked about what are the trusts imposed by section 33. Essentially, they're trusts to preserve the assets, deal properly with them, apply them in due course of administration, etc. Then he says, Lord Ratcliffe says, they might just as well have been termed duties in respect of assets as trusts. Well, yes, I think all trusts are duties in respect of assets. But certainly they are duties in respect of assets. But what equity didn't do was recognise a beneficial interest for the residuary legatees in the assets in the executor's hands during the course of administration. And that, of course, is what this case is really about. It's whether it created a beneficial interest. It explains that it might have done, but it didn't, because it wouldn't have worked very well, because it's a fluctuating fund because of the creditors. So, in other words, it's not compatible with what he says are the basic conception of equity. This is over the page now, A, to impose the fetters of a trust upon property. But when he says that, he clearly means trust in a different sense from the sense he was using it on the previous page, because he said that there are trusts for certain purposes and in some aspects. So he's explaining the difference between the two things, all of which I accept. And then the start of the next paragraph, at the date of Mrs. Coulson's death, therefore, there was no trust fund consisting of Mr. Livingston's residuary estate in which she could be said to have any beneficial interest, because no trust had as yet come into existence to affect the assets of his estate. Well, again, when he says because no trust had as yet come into existence, this isn't a statute, it's case law. We have to read that phrase in the context of what he said on the previous page, that it's a trust for certain purposes and in some aspects.
But he doesn't actually say that. He says that for certain purposes and in some aspects he was treated by the court as a trustee.
Yeah.
Yes.
Not saying that it was I suppose you could turn that round, but it is treated as a trustee.
Yes. I think in light of section 33, which says is held in trust, not is treated as held in trust, I'm not sure that that's a problem for me. Again, one doesn't want to read the words treated there in a statutory sense. This is a judgment, and so I don't think that what Lord Radcliffe had in mind there was saying that an unadministered estate is merely deemed to be a trust for certain purposes. He's saying that the courts treat it as, they act as though, they treat it like a trust in the narrow sense.
But your primary submission under this heading is that outside section 33 has been held that PRs hold property in trust. And speaking for myself, it seems as though this is saying the opposite, particularly at the top of page 708, an unadministered estate was incapable of satisfying this requirement, i.e. the requirements that were necessary for it to be essentially a trust.
And what he's saying there is that it can't satisfy the requirements necessary for the residuary legatee to have a beneficial interest. He does, I accept, say, as I've pointed out in a couple of places, that it's not imposing fetters of a trust, or that no trust had as yet come into existence. When he says that, he means trust in the narrow sense, as in express, constructive or resulting trust. He doesn't mean trust in the sense that he's talked about above, certain purposes and in some aspects. I think I'll come on to AEST in a moment, which perhaps explains this point a little bit further. I understand what my lord is saying, but in my submission, he is saying that these are trusts. They're just trusts of a different kind from trusts in the narrow sense.
But it's a fundamental aspect of a trust, isn't it, that there is identifiable trust property which can be said to be held for the benefit of a third person?
Is a fundamental aspect of a trust in the narrow sense of the word, yes, but...
Well, why do you add the narrow sense of the word? I mean, a trust is a trust, and a trust requires those elements.
A trust in the narrow sense of the word does, but we can see that section 33 says held in trust. That creates a trust. So the statute tells us this is a trust. Clearly, what Livingston tells us is that, although he's not referring to section 33 because it's Australia, what Livingston tells us is that the type of trust that section 33 is talking about doesn't have all the same indicia of a trust in the narrow sense of the word, that there are two senses of this word.
Passage at F, beginning it may not be possible. Those first sort of 10 lines tend to support them. idea that what he's saying there is that he describes them as trusts, but he then says they might just as well have been termed duties in respect of the assets. And so what he seems to be talking about is what we would say would be fiduciary duties in respect of the assets. And it's in that sense that the personal representative is a trustee, but he's not really a trustee in a classic sense at all. And that's effectively what the judge has decided.
The duties are not just fiduciary duties, they're much wider than that. The fiduciary has a duty not to make a profit and not to put himself in a position of conflict. The Section 33 duties are a duty to pay creditors, set aside a fund for residuary legatees, all sorts of other things. There are powers to invest, like trustees usually have. And then, of course, there are other equitable duties.
Which of the duties that's identified at F would not be a fiduciary duty? Otherwise described as a fiduciary duty, because it seems to me they would all be. Preserve the assets, deal with them properly, apply them in due course of administration for the benefit of those interested.
So we've seen that they have a power to sell, for example. That's one of the classic powers of personal representative. In exercising that power of sale, if they exercise that power negligently, they haven't breached their fiduciary duty to anybody, but they have breached an equitable duty of care and skill that's been imposed on them because of their trustee-like status. So these are duties that are enforceable in equity. They go wider than mere fiduciary duties, but they share many of the duties that trustees have in equity.
This must be obvious, but there's no equivalent to Section 33 in Queensland. Was there at the time of that decision?
Not as far as I can find out from reading this decision. I haven't researched the point under the law of Queensland in 1964, but there's nothing in the judgment that refers to such a provision. And I suppose one might expect that there would have been it would have been referred to if it were there. So yes, I say in the specific statutory context of Queensland succession duty, this decision is authority for the fact that a residuary legatee doesn't have a beneficial interest in the estate assets. In a bit, I'll come on to Earnshaw and Hartley, which says that reasoning about beneficial interests doesn't actually hold good in the context of adverse possession. But in any event, the statutory question that paragraph 12 is posing is whether it's subject to a trust, not whether the beneficiary has a beneficial interest in it. Turning to Ayerst, which is tab 11, it's another case very much in the same line as Livingston. What this is authority for, in short, is that the company ceases to be beneficial owner of its assets when a winding up order is made. Again, it's in the context of a tax statute. And the key passage in the judgment is page 129 of the authorities bundle. It's Lord Diplock's judgment. And if I could ask your lordships again, just to read the marked passage, the passage marked with the black line.
Ayerst, is it?
Ayerst, exactly. Pages 129 to 130 of the authorities bundle.
Do you want to read that? What, from G?
Yes, my lord. So those last 4 or 5 lines, no misuse of language to describe the property as being held by the trustee on a statutory trust if the qualifying adjective statutory is understood as indicating that the trust doesn't bear all the indicia which characterise a trust as recognised by the Court of Chancery. So I say that that applies to the Section 33 trust that we're looking at. Lord Diplock's just been talking about unadministered estates as well as trustees in bankruptcy, etc. And what he explains is trust has 2 different meanings, and where the word trust is used, it's wrong to import all the features of a trust in the narrow sense and assume that they're going to apply to the statutory trust that has been created or that has been recognised in equity. But that doesn't mean that it isn't a trust. You just have to be careful with what you mean by trust. So then, in terms of the indicia, to use that word, that are shared between an unadministered estate and a trust in the narrow sense, well, in both of them, the legal owner is not the beneficial owner. Beneficial ownership is elsewhere. It's either in a beneficiary in an ordinary trust, or it's, as it were, in suspense in an unadministered estate. Then the right to due administration, which the residuary beneficiary has, is a right to performance of the trust in Section 33(1). That's a right enforceable in equity, as we've just been discussing, just as the right to execution of a trust is a right enforceable in equity. Of course, they're both fiduciaries, both custodial fiduciaries. And then legatees also have the same right as trust beneficiaries to follow and trace estate assets if they're misapplied. If reference for that's required, Williams, Mortar and Sunnock's in the bundle at 7401, tab 28 of the bundle. And a legatee, of course, can also assign their right to due administration to a third party, just as a trust beneficiary can. So there are very considerable similarities and overlaps between an unadministered estate and a trust in the narrow sense. They're not just 2 entirely different things that the same word has been applied to. Obviously, they can't be completely assimilated. That's what Livingston and AS tell us. But they are, I say, fundamentally similar, and so it's not surprising that Parliament in Section 33 decided to use the word trust to describe the unadministered estate. Then my third submission is that interpreting trust to include an unadministered estate creates a consistent scheme as between the 2002 Act and Limitation Act 1980. So that takes us to the Limitation Act 1980, that's tab 3 of the authorities bundle. We saw earlier that section 15 was referred to in paragraph 11.1 of schedule 6 of the 2002 Act, because whether you're in adverse possession or not depends whether time would run against you under section 15. Section 15.1 says no action shall be brought to recover land after the expiry of 12 years from the date on which the right of action accrued or to their predecessor in title. It doesn't actually tell us when the right of action accrues. Subsection 6 just below tells us that to find that out we have to look at Schedule 1 of the Limitation Act 1980. Before I get there, I also want to look at section 21 of this Act. So that's at page 26 of the authorities bundle, section 21 of the Limitation Act, which is the period that disapplies limitation periods where in an action by a beneficiary under a trust, being an action B, to recover from the trustee, trust property or the proceeds of trust property in the possession of the trustee or previously received in courtesies use. So in the context of estate land, what this does is it switches off adverse possession where the trustee is in possession. So the trustee can't, the administrator or whoever can't sit in possession of the land and then bar the residuary beneficiary's title And the reason for that in both registered and unregistered land is this provision, which switches it off.
Sorry, just say it again.
Yes.
This prevents any, so in relation to unregistered land,
Yes.
creates any adverse possession operating as against a personal representative.
It prevents the trustee from claiming adverse possession as against the beneficiary,
Right.
because it's trust property that's in possession of the trustee. So the usual 12-year period doesn't apply, and it doesn't apply because time never starts to run because of this section. And of course, because we're in the Limitation Act here, we have the benefit of a definition of trust, etc., which we don't have the benefit of in the 2002 Act. I can take you to them. It's section 38(1), which refers through to the Trustee Act 1925, section 68(17). Perhaps we could go straight to 68(17) because that's actually the definition that applies. So that's tab 2 at page 18. So 68(17). Trust does not include instant aware of mortgage, forget that. But with that exception, the expressions trust and trustee extend to certain types of trust and to the duties incident to the office of a personal representative, and trustee, where the context admits, includes a personal representative. So I would make a similar point to the point I made earlier about applies. It says extends and includes. It doesn't say shall be treated as including for the purposes of this Act. It just says extends. So that's what trustee, beneficiary and trust are defined to mean in the Limitation Act 1980, unless the context otherwise applies, of course. And then I think we can go back to the Limitation Act and to Schedule 1 of that Act. And specifically to paragraph 9 of Schedule 1, which is on page 34. So where any settled land or land held subject to a trust of land is in the possession of a person entitled to a beneficial interest in the land, not being sole beneficiary, no right of action to recover the land shall be treated for the purposes of this Act as accruing during that possession to any person in whom the land is vested as, among other things, trustee, or to any other person entitled to a beneficial interest in the land. So quite compressed drafting, but what it does is prevent a right of action from accruing where one beneficiary is in possession, so they can't claim adverse possession against another beneficiary who's out of possession. And it also prevents the beneficiary from claiming adverse possession against the trustee. So the reverse of the Section 21 situation, if you like. And again, this, because it talks about trusts, we know from the definitions that it applies to unadministered estates. I'm going to go in a moment to Earnshaw and Hartley that explains that where it talks about a beneficial interest in the land, i.e. the last line, and indeed the second line, that includes residuary beneficiaries of an unadministered estate. So this deals both with trusts and unadministered estates. And it's quite important to note that this provision still applies to registered land as well as unregistered land. And that's because you can only be in adverse possession of registered land if time runs under Section 15, and time only runs under Section 15, or rather time doesn't run under Section 15 if you're within this paragraph. So this provision that applies equally to trusts and estates also applies equally to registered and unregistered land.
But if you're looking, this is in support of your argument for consistency. The route that you get there is because of the definition of trust in section 68(17). And without that, the argument might be different. And
My argument,
without that in the Land Registration Act.
my argument is that because the statutory schemes interlock in this way, the starting point is, I'll come to this in a moment, but the starting point is that you look at the definitions in the related act. So I think that's a good place then to turn to Earnshaw and Hartley, which explains paragraph 9 a bit more. This is at tab 16 of the authorities bundle, starting on page 204, decision of this court, leading judgment given by Lord Justice Norse. Facts in this case, the deceased died intestate with a son and 3 daughters who survived her. Her estate included a farm and a farmhouse. She'd lived there with her son during her life. When she died, the son continued to live there, and later his wife, the son's wife, who was his executor and sole beneficiary, continued to live there as well, so she was his successor in title. They'd been there for more than 12 years before a grant was taken out, and the son dies. His widow, successor in title, says that she's acquired title by adverse possession. Deceased's daughters, unsurprisingly, aren't very happy about this, and they say, no, you haven't, because of paragraph 9, we're co-beneficiaries, so time doesn't run against us. And then there's an argument whether the residuary beneficiaries, any of them, particularly the husband who was in possession, did he have a beneficial interest in the land for the purposes of paragraph 9? And what the widow argued was, no, he doesn't, because Livingstone's case tells us very clearly that the residuary beneficiary of an unadministered estate does not have a beneficial interest. But what Lord Justice Norse says, this is at page 210 of the authorities bundle, around about letter B. So first he talks about the position before the grant. I don't think we need to worry about that here because there was a grant within the 10-year period. He says it's an artificial distinction between pre and post grant. Then he goes on and says it would be equally artificial for limitation purposes to hold that after the grant had caused the trust for sale under section 33, so that's the pre-96 trust provision of section 33, to take effect. Daughters did not have beneficial interests in the proceeds of sale of the farm. And then he refers to a case of Miss Justice Buckley and says that the interest of a kind that a residuary beneficiary has is a sufficient interest for the purposes of paragraph 9, i.e. in this very different statutory context, very different from Livingstone, a residuary beneficiary does have a beneficial interest. So even though they don't, under that very strict tax and conflict of laws analysis that we looked at in Livingstone, they do have a sufficient interest for the purposes of adverse possession in paragraph 9. So that shows that one has to be quite careful in taking that strict approach in Livingstone and applying it in other contexts, and particularly in the context of adverse possession. So what do I take from these references to the Limitation Act? Well, I've shown that Schedule 6 of the 2002 Act incorporates from the 1980 Act many of the provisions about adverse possession and the running of time, and that those rules apply to trusts and estates without distinction because of the definition provisions, as my Lord says. And if we read paragraph 12 of Schedule 6, the paragraph we're concerned with, in that statutory context, I say it's unlikely that Parliament intended the word trust to have a different meaning there from the meaning that it has in the rest of the provisions about the running of time in unadministered estates. The provisions that deal with disputes within a trust all apply to unadministered estates, so why shouldn't paragraph 12 apply as well? That must at least be the starting point, is my submission. And I've also said in my skeleton argument, and say again, that where you have two acts which form a single code on a particular matter, they're in pari materia, so they should be construed as one. Part of that rule is that there's a presumption that a definition, that where a term is only defined in one of the two acts in pari materia, that definition can be read as applying to the act where no definition is given. The references for that are Begum 18.9 and Begum 21.5 under tab 24 of the authorities bundle. My submission is that these acts, or at least these parts and schedules, are in pari materia with one another, in that they deal with the same subject matter, namely adverse possession. And so they should be construed as one. If I'm wrong about that and they're not strictly in pari materia, then a contextual and purposive approach to statutory construction takes you to the same result, really, because when we're reading paragraph 12, we don't read it in isolation, look at the other provisions, including provisions incorporated by reference. Then my fourth submission is focusing back on the language of paragraph 12. There's nothing in there, I say, that indicates an intention to exclude unadministered estates. So paragraph 12, that's page 49 of the authorities bundle, just to look at it again. The exception is unless the interest of each of the beneficiaries in the estate is an interest in possession. And what the learned judge said below was, well, that suggests that the type of trust that the drafter was thinking about was the type of trust in which people have interests in possession. That's not right in my submission, because, well, I should just note there that, of course, if that is right, then estate beneficiaries don't have interests in possession, which is the second part of my case. I certainly say they don't have interests in possession. But leaving that aside, there are plenty of trusts, even in the narrow sense of the word that we've been discussing, where none of the beneficiaries has an interest in possession. Two obvious examples: discretionary trusts. If it's discretionary trust, then by definition, none of the beneficiaries has an interest in possession. And the other obvious example is a charitable trust. Clearly, nobody has an interest in possession in a charitable trust. So the drafter has used the word trust. That word must include discretionary trusts and charitable trusts. And
well, a discretionary trust, there is the possibility of a beneficiary becoming in possession, isn't there, with a discretionary trust?
There is, and when an unadministered estate is fully administered, they have interest in possession as well.
But with a charitable trust, there's no beneficiary that could ever be in possession, because the beneficiary is charity itself, isn't it?
Not if it's a hybrid trust. So, for example, a trust for charity for 10 years and then for my son when he turns 21, and or vice versa. You could have a trust for my wife for life and then for charity. Okay, there's an interest in possession for the wife there, but then afterwards there isn't. Or you could have 50-50 between the wife and the charity.
But those are trusts where there is at least the potential for a beneficiary to come into possession. A pure charitable trust, there is pure charitable trust.
Yes, but I think I find it hard to imagine that the drafter of this section thought that it should matter whether something was a pure charitable trust or not. They're talking about trusts. A charitable trust is a trust. It fulfills all those definitions that we were looking at before to do with an identifiable fund and all that sort of thing. All the provisions of the Trustee Act that you'd expect to apply to a trust apply to charitable trusts. There are, of course, some differences, but it's hard to go much further than the submission that a charitable trust is a trust. It really just is. And the fact that one can have hybrid trusts that are part charitable and part not underlines that, because you can have one trust instrument that is both charitable and non-charitable, or flips between the two. So they're not just thinking about the types of trust where you can have an interest in possession. They're thinking, or where there are interests in possession at a particular moment. They're thinking about all types of trust in my submission. And it's also important here to think about what is it that differentiates a trust with an interest in possession for the purposes of adverse possession from another trust. And the difference is that if all the beneficiaries have an interest in possession, then all the beneficiaries, any of the beneficiaries, can bring a possession claim. In my skeleton, I cited McGarry and Wade on that point, but I thought I should actually provide case law in this court, and the authority is Brake and Cheddington Court Estates, tab 21 of the bundle. Judgment of Lord Justice Lewison. I do think the facts are important, but page 302 of the authorities bundle, paragraphs 40 and 41, explains the effect of the Judicature Act on possession claims. So, page 302 of the authorities bundle. Paragraphs 40 to 41. So what it says is that the common law courts and courts of equity brought together under the Judicature Act both administer law and equity concurrently in the event of conflict. Equitable rules provide. Then refers to judgment of Sir George Jessel. He says, considering especially that the jurisdiction in equity and common law is now vested in every court of justice, so that no action for ejectment, or as it's now called, an action for recovery of land, can be defeated for the want of the legal estate, where the plaintiff has the title to possession. So, in other words, if you've got equitable title to possession, i.e. an interest in possession, then you can't be defeated by your lack of a legal title. And then paragraph 41, McGarry and Wade, explains that a bit further, or rather confirms what's being said. The amalgamation of the two jurisdictions consummates the reform that reverses the confinement of an action of ejectment to claims at law. So, if you're entitled in possession to the land in equity, you can bring a possession claim to get the squatter out. So that puts you in a substantially different position from somebody who is not in possession, whether that's a remainderman, a discretionary beneficiary, the object of charity, or in our case, a residuary beneficiary of an unadministered estate. None of those people can bring a possession claim, but someone with an interest in possession can. So that's the real dividing line, I say. It's a principled dividing line that fits with the statutory language. So that's what I had to say about the wording of the exception. My fifth submission is about pre-legislative materials, and that they indicate an intention to include all trusts of land and therefore unadministered estates within the meaning of trust. The materials here, it's the 1998 consultative document and the 2001 joint report, both jointly done by Law Commission and Land Registry. Obviously, the primary source for ascertaining Parliament's intention is the words of the statute. These only have a secondary importance. The case of and Home Secretary is the authority for that in the bundle, powers that 29 to 30, but I'm sure your Lordship's very familiar with that. The consultative document is tab 22, and if I could start at page 322 of the authorities bundle. So paragraphs 10.5 to 10.10, the authors set out what they say are the four justifications for adverse possession, namely 1, barring stale claims, 2, ensuring that ownership and possession don't get completely out of kilter, 3, preventing hardship in cases of mistake, and 4, in unregistered land, relativity of title means that title depends on possession. At 10.10, they say that justification 4 is the strongest justification, but that obviously it doesn't apply to registered land. So we only have to think about justifications 1 to 3. And in paragraph 10.6, they say about 4 lines from the end of that paragraph, or 4 lines from the end of that page rather, in any event, this particular justification has much greater force in relation to unregistered land than land with registered title, because of course in an unregistered system one shouldn't let claims go stale, because of course you're going to lose possession. There's good reasons for ensuring that there aren't stale claims there. It's a weaker justification for registered land. Then turning on a couple of pages to page 324 of the authorities, this is where at 10.13 onwards the author set out 4 situations where at this early stage they thought retaining adverse possession could be justified. In summary, they are disappearance of the registered proprietor, dealings off the register, cases where the register is not conclusive, like boundaries, and entry into possession as a reasonable mistake as to rights. The first 2 we need to look at in a bit more detail because they refer to estates. 10.13 starts, it sometimes happens that a registered proprietor abandons his or her land or dies in circumstances in which no steps are taken to wind up his or her estate. So it might be said against me, this suggests the authors thought that adverse possession should still be available for an unadministered estate. One has to be quite careful what this is actually talking about. It's talking about cases, as the heading to this section says, where the registered proprietor has disappeared and cannot be traced. So abandonment or someone who dies and no steps taken to wind up the estate. So the mischief here is that the registered proprietor has disappeared and cannot be traced. It's not directed, I say, at cases where a grant has been made, because obviously a grant is quite a substantial step that is taken to wind up an estate. And the PRs, of course, once a grant has been made, unless they abandon the land too, they're perfectly traceable. So there's no question of the land being rendered sterile.
So you say that the words in 10.13 must be construed in light of the heading?
Yes.
Only applying where someone has disappeared, cannot be traced, and has died?
Well, maybe the disappearance is the death. It's talking about cases where where the registered proprietor cannot be traced, whether because of death or abandonment. It's not talking about a case where someone dies and then somebody takes out a grant. And under the new law of adverse possession, in fact, this case is still properly catered for, because if I'm a squatter in possession of the land of someone who's died for 10 years, and I send in a notice to the land registry saying, please register me as proprietor, that notice is going to go to the deceased proprietor. They're dead, they can't respond to it, and so I'm going to get registered. So their case is catered for, even under the reformed law. So that's that example. It doesn't actually recur in the joint report anyway, this example, but anyway, for what it's worth, I say that mischief's fixed by the new law. The next example, 10.4.
Sorry, I'm not following that point. Why it's fixed under the new law. If someone dies and no steps are taken to take out a grant, then someone can acquire adverse possession, you say?
Yes.
Right. Because there's no trust at all until the personal representatives are appointed.
Yes, exactly.
Right.
And in any case, there's nobody to respond. So you send in your notice, it goes to the deceased proprietor, presumably it will go to their registered address. And because nobody's taken out a grant, nobody's updated the register, etc., there's nobody to respond to that notice.
But the mischief you're concerned with, that there are in fact people out there who are entitled to inherit this land, don't know about what's going on, and they are prejudiced.
I suppose if there are cases where, for for 10 years, they've been unaware and there's nobody's taken any steps whatsoever, then yes, I accept that those people would be prejudiced, if I'm right about that point.
The policy of the Act is they're out of the picture.
I think that the correct reading of the Act is that if really after 10 years nothing whatsoever has been done, then yes, I'm not sure that paragraph 12 does protect them. It does protect them if the simple step of applying for a grant has been taken. 10.14 is the next exception that the Law Commission was planning to preserve, and that's dealings off the register at subparagraph 2 over the page. So this is page 325 now, where the registered proprietor dies and the property is taken over by her daughter who was to inherit it, but where no steps are ever taken to register the title. If I may, I'm going to come back to that when we look at the joint report, because the same example occurs again, but it's explained in a bit more detail. Then, just before leaving the consultative document, I think it's worth looking briefly at its proposal for successive interests, which is paragraph 10.77 at page 353 of the authorities. So, at this stage, at the consultative stage, what this tells us is that the proposal was where you had successive interests, as they call it, then what the squatter would get was qualified title unless the squatter could show that the land wasn't held for persons in succession. The reason I point that out is that obviously that's not exactly the solution that paragraph 12 adopts. So that's a reminder that this is a consultative document and has to be handled with a little bit of care. Turning to the report itself, page 368 of the authorities bundle, to make an obvious point, this is post-consultation, it's a more important document. It was accompanied by the draft bill that was enacted as the 2002 Act. We don't have a copy of the draft bill in the bundle, but it did have paragraph 12 in it. And going to page 372, paragraph 14.6 sets out the aims of the new scheme proposed by the report. And at paragraph 2, this is familiar in part, says if the application is not opposed, however, over the page 373, that wasn't clear, and subparagraph 2.
I've got it.
Yeah,
thank you.
if it's not opposed, whether because the registered proprietor has disappeared or is unwilling to take steps to evict the squatter will be registered as proprietor instead. This ensures that land that has been abandoned or which they don't consider to be worth the price of possession proceedings remains in commerce. Note, no reference here to death. So there's a change from the consultative document. So it may be that the authors no longer thought that the situation they'd mentioned in the consultative document needed to be fixed, or needed to be protected from adverse possession, as it were, or within the scheme. But in any event, certainly it shows that the focus here is on disappearance. Then turning to 14.43, so this is page 392 now, moving on a bit. Under the heading Some Other Right to the Land. So this is within the section of the report that explains the 3 savings for adverse possession that we were looking at earlier. So estoppel, some other right, and boundary. Under some other right, I have to say, I've always found this a slightly odd provision, because if you're entitled to be registered by some other right, why do you need adverse possession? Anyway, I can only shrug at that. Example 1 here is the claimant is entitled to the land under the will or intestacy of the deceased proprietor. So that's like the daughter who we saw mentioned in the consultation document. What's this talking about? Well, clearly it's not referring to the situation where, let's call her the daughter again, where she's one of several beneficiaries, because we've seen that Limitation Act Schedule 1, paragraph 9 prevents time from running where there are several beneficiaries entitled to the land. So it's not talking about that situation. So it must be talking about a case where the daughter's the sole beneficiary. But if the estate hasn't been fully administered, the claimant isn't entitled to be registered. And that's because her claim is subject to the prior claims of the creditors, including HMRC, for example, for IHT. So she's not entitled to be registered, so she's not within this. And if she was, then beneficiaries could use this provision to defeat the usual order for payment under the Administration of Estates Act, prejudicing creditors, including HMRC. It's clearly not what the authors had in mind here. What they had in mind was the situation where the estate had been fully administered, because once the estate's been fully administered and there's only one beneficiary, the land is held on bare trust for them, and they are entitled to be registered. Time does run for the purposes of Section 15 of the Limitation Act, and they become entitled to be registered once the statutory time period has elapsed. So this isn't an example about unadministered estates at all. It's an example about fully administered estates. So I say there's nothing in the joint report that indicates that time was supposed to run in unadministered estates. The only reference in the consultation document to unadministered estates is to that case where the proprietor has simply died and disappeared, and no grant impliedly has been taken out. So, in other words, the examples that seem to be about unadministered estates don't actually provide an indication that the authors were, well, I should correct myself, we're not interested in what the authors subjectively thought, we're interested in what Parliament intended.
Yeah.
But it doesn't provide evidence of what Parliament intended in respect of unadministered estates. Then the final part of the joint report that I need to go to is paragraph 14.91, page 411. So this is the part that actually explains paragraph 12, so far as it's explained. The first sentence here says, the application of the new scheme to land held in trust has caused us some difficulty. They then go on and explain why they've abandoned that idea about qualified title that we were looking at. But the important point for my purposes is footnote 288, which glosses the words land held in trust. And the gloss is whether there is a trust of land or a settlement made under the Settled Land Act 1925. Obviously not interested in Settled Land Act settlements, interested in the bit whether there is a trust of land. So the only gloss in the joint report on what a trust means says that it includes trusts of land. And we know from Talata whether in fact Section 18 is a deeming provision or not. We know that personal representatives hold on a trust of land. So the only gloss says, yes, trusts of land included, and we know what that means. It means that unadministered estates are included. So your conscientious parliamentarian who wondered, does trust include an unadministered estate, can look at the relevant section of the joint report, 14.91, they can see that gloss, and if they do a bit of legal research, if they look at Section 18 Talata, they can work out, oh yeah, trust of land, that includes unadministered estates. Therefore, in enacting this provision, that includes unadministered estates. The report over the page does go on to provide an example of paragraph 12 that refers to successive interests, but they are just it's just an example, just an illustration. It's not an exhaustive description of cases where paragraph 12 is intended to apply, and as I've sought to say, discretionary and charitable trusts would fall within it as well, and they're not mentioned there either.
14.92 says the manner in which the bill deals with adverse possession of registered land is necessarily different from the approach adopted in the 1980 Act because they rest on different principles.
Yes.
But you say they should be treated as though they're part of one scheme.
Well, yes, because although there are necessary differences, adverse possession itself is defined with reference, is defined by the Law Commission's own bill with reference to section 15 and the schedules of the Limitation Act. So although there is, I accept, of course they're different, the regimes are fundamentally different in many ways, but they are about the same subject matter, and they do use the same definition of adverse possession with modifications, of course. But modifications.
What's the purpose? Do we draw any help from this of the purpose that would be behind excluding unadministered estates from the application of adverse possession principles otherwise?
There's nothing that expressly says, of course, they want to exclude them, otherwise I'd have an easier time of it.
What do we draw from this that helps us understand what paragraph 12 might mean and why it might be intended to include as you submit unadministered estates?
My submission is that it's about cases where the beneficiary can, as it were, defend themselves. They're entitled to a possession order, and so if they have an interest in possession, they're entitled to a possession order, so they don't need the protection of paragraph 12. What paragraph 12 does is create a scheme that protects people who can't claim possession themselves, but doesn't protect other people. So it's, in effect, it's assimilating the position of charitable trusts, discretionary trusts, and unadministered estates to the position of a strict settlement with successive interests. Because the common theme with all of them is that they're trusts, but not everybody has an interest in possession. Potentially only some of them do, or none of them.
The legatees could act, couldn't they, so as to protect themselves by requiring the trustee to take action?
The same would apply to a remainderment, though. So, well, suppose that I'm a remainderment under settlement for A for life, then me in remainder, and if I am aware that the land is in adverse possession, the trustee's not doing anything about it, I think if I applied to the Chancery Division for a direction that the trustee bring a claim, the Chancery Division would be very likely to direct that the trustee bring a claim.
What would happen if you didn't exist?
Sorry, I didn't catch
What would
that.
happen if you didn't exist?
As remainderman?
Successive interests. You could have a successive interest in a person that was not yet born.
Yes.
So that would be a reason why you might apply to such trusts, but the position would be different with unadministered estates.
Yes, that's true. Although if you have a settled unadministered estate, then the remainderman there might not be born either. And they don't get the protection of paragraph 12 during the administration period, if the learned friend's right about its interpretation.
And paragraph 1493, we're going to come to.
Yes, 1493. So this is the illustration that I was mentioning, so I should have said both paragraphs, 14.92 and 93. It illustrates an example of how paragraph 12 can work, but it's not seeking to exhaustively state all the situations in which paragraph 12 works.
If you look at the explanatory notes for the meaning of trusts, that uses the words the purpose of paragraph 12 is that where there are successive interests. So I think one can extrapolate from that, the paragraph 1493 is talking about the purpose of this provision is addressing successive interests.
Well, perhaps it depends
Where
what,
there are successive
perhaps
interests.
it depends what's meant by successive interest, because a discretionary trust, where you know, if you've got a wide class of discretionary beneficiaries, and then after that you have a, you know, at the end of 125 years, you have remainder to the Red Cross or to my children in equal shares or whatever. In that case, I do think most trust practitioners would usually describe those as successive interests, but undoubtedly the people at the end of the 125 years are still protected by paragraph 12. In my case, the interest that the beneficiaries of the unadministered estate have are successive to whatever interest the personal representative has during the administration period. So you have first one thing and then the other. That's a successive interest.
Well, in that situation, what interest does the personal representative have?
Livingston says the undifferentiated interest. They don't have the beneficial interest.
Right.
The beneficial interest is in suspense. I think that's the best way of putting it. But the same is true of the discretionary trust, that the objects of the power to benefit them, they have a mere hope of benefiting. Beneficial interest isn't in them either. Beneficial interest is in suspense during the discretionary period. AEST, of course, reminds us that the beneficial interest doesn't always have to be vested somewhere. It can just be in suspense. So yes, I say that successive interest includes cases where one stage in the succession is a suspension of the beneficial interest. Charitable trusts would be another example. So that was all I was going to say about the pre-legislative materials.
Yeah.
My last two of my 7 submissions are much briefer. So the 6th is anomalous results, and actually that leads on from where we just were. So the anomalous results that I say results from a friend's interpretation is that where you've got settled residue, you have protection for the remainderman after the assent, but not before. Just for context here, of course, it's very common in a will for the residue to be left for a spouse for life, then for children, a remainder or something like that. Back in 2002, that happened under intestacy as well, because the surviving spouse got a life interest. That's no longer the case, but we have to think about what it was like then. So settled residue, very common situation, and it's odd to distinguish between the situation before and after the end of the administration. Worth bearing in mind here that the administration period can be quite extended, and properly so, if you've got contingent liabilities, and the contingency under which the liability falls in is only going to happen in several years' time. The estate can't be fully administered until you know whether that is going to hit you. Similarly, you can have assets that are difficult to collect or realise, like a partnership share or something like that. And you can have, under a will, you can have legacies that take effect many years in the future, or are conditional on the happening of an event. So the administration period can be, quite properly, significantly extended. During that period, I can't see any policy reason why paragraph 12 shouldn't give those remaindermen the protection that it gives once the administration period has concluded. They're in a fundamentally similar position before and after the administration has concluded. My interpretation is sensible in that it protects them before and after without an artificial distinction. based on the conclusion of the administration period. That's a better interpretation than the interpretation that creates that artificial dividing line.
This could apply in the intestacy of a life tenant.
No, because their assets would vest, so their life interest doesn't go by their will, unless they've got a testamentary power of
So the
appointment.
anomaly you're talking about could never arise in an intestate situation, could it?
Sorry,
Could the anomaly you're talking about ever arise in the case of intestacy?
it could have done when intestacy created a life interest for the surviving spouse, yes, and that was the case in 2002.
Because your anomaly, you say, your anomaly would still arise, wouldn't it, if no letters were taken out, if no grant was.
Yes, I think that's right. But if a grant is taken out, if people are acting properly, they take out the grant, and the estate is in the course of administration, so post-grant, but before completion of administration. As I say, that might last for many years, contingent liabilities, etc. And during that period, the surviving spouse, she's got her, or he has his life interest. The remainder beneficiaries are not protected by paragraph 12, if my learned friend is right about its interpretation. And I just say that's a very odd result. There's no need to interpret the statute in that way. Better to interpret it in my way to avoid that anomaly. Then my seventh and final submission on trusts is the point about consistent interpretation with the meaning elsewhere in the Land Registration Act 2002. That arises from the same word, same meaning rule of statutory interpretation. That's in Begum 21.3. Don't think I need to go to it. Obviously only a presumption anyway. The relevant provision I rely on in the authorities bundle is section 78 LRA, which is page 39 of the authorities bundle. Nice short section. Notice that registrar shall not be affected with notice of a trust. Does trust here include an unadministered estate? I say clearly it does, and that's because, as I mentioned earlier, the residuary beneficiary, an unadministered estate, has the same rights as a trust beneficiary to follow and trace trust land, for example, into the hands of third parties. And the purpose of this provision is to stop the register from being cluttered up with equitable interests of various kinds. I use equitable interests in a slightly loose sense there. The purpose that extends to strict equitable interests must extend to the interests of beneficiaries in unadministered estate. The curtain must be drawn across those interests as much as it is drawn across interests under a trust in the strict sense. Yeah. So that's my seventh submission. What I was going to do next is to turn to the decision, well, to two decisions. First, the decision Best and Curtis, because that's relied on in Miss Justice Freedman's decision. Then I'll go to the decision below. So Best and Curtis, this is page 225 of the authorities bundle, tab 18. Decision of the FTT property chamber, but I accept has some authority from the judge, Elizabeth Cook, of course, very distinguished specialist judge. Facts here were that Mr. Best had applied to be registered as proprietor of a house, which the late Mrs. Curtis had been registered proprietor of. She died all the way back in 1988. At the time the application for registration was made by Mr. Best, Mrs. Curtis's son, who was entitled to succeed on her intestacy, hadn't yet taken out a grant. And what Judge Cook holds is that during the time, in fact, before the grant, she holds that the land had been in adverse possession, and she holds that the son had in any event not been entitled to give notice objecting to the application because he had not obtained the grant when he gave the notice. So it's a little bit like it is a disappearing proprietor situation, if you like, unlike the case that we're talking about where a grant was taken out within 10 years. And the key passage of the decision, paragraph 20 onwards, page 229 of the bundle. Two things to note about this. First, there is no mention in this decision of section 33(1) of the Administration of Estates Act 1925. I assume it wasn't drawn to Judge Cook's attention because I think otherwise she would have surely mentioned it. And secondly, no reference in this decision either to Talata. So the two key statutory provisions that I rely upon, I assume were just not cited to Judge Cook in the FTT. In light of that, I say that although I want to give proper deference to Judge Cook as a specialist judge, the weight to be given to this authority is pretty limited actually, because if it doesn't refer to the two key statutory provisions, it's not all that helpful. In any event, the estate was vested in the public trustee pre-grant throughout the 10 years that Mr. Best relied on. So the remarks that Judge Cook is making about the position after the grant, strictly speaking, aren't fair to. And she makes some points about Livingston, etc. I think those points are all developed better in Mr. Justice Freedman's judgment. So if I may, I'll turn to that now.
This point about the whole 10 years expiring before the grant was taken out, that doesn't matter, does it? Because don't you have to be in adverse possession the day before or at the time you make your application?
Only if you're defending a possession claim.
You're making a positive claim.
So let me check that I'm right about this, but I think the answer is in Schedule 6. No, sorry, I am wrong about that. You do have to have been in adverse possession for a period of 10 years, so yes.
So it's a bad point in this case.
You're quite right, my lord, I'm sorry. Yes, so in fact they had to be in adverse possession until the date ending, but the date ending in the application is before the grant. So, no, sorry, I am right. The grant wasn't taken out at the date of the application.
On the facts.
On the facts, yes, exactly. So the 10 years were all pre-grant. So may I turn to the judgment now? That's in the core bundle, tab 9, or page 97. I'll start on page 97 because that's where the discussion section starts. And in this case, section 33(1) was cited below, or at least the judge was aware of it, but the learned judge's attention doesn't actually seem to have been drawn to Talata at all, let alone to that footnote that I took you to in the joint report about trusts of land. So actually, possibly the most important building block in my argument wasn't run before the judge below, because my clients were acting in person at that stage. Looking at the points in turn, starting with little Roman 1, there's the reference to Williams, Mortimer and Sunnox here. The representative in their capacity as representative is not, strictly speaking, the trustee. Discusses the type of interest that the representative has. Now, if strictly here, if that means narrowly, obviously I accept that. I keep saying narrowly, and that's because strict is an ambiguous word. It can be narrow and it can mean correct. But I say that what it means here is narrow, and in any event, this is just commentary in a textbook. It's not a statute. So, in the narrow sense, doesn't include trustee, doesn't include PRs. Well, I accept that, but in a wider sense, it does. Then, little Roman 2. The sense in which trust is used in section 33 to make administrators subject to fiduciary obligations in the management of the estate. that not to make that which is not a trust into a trust. The sense in which it's used is not to make that which is not a trust into a trust, is what he's saying. I find that reasoning a little bit difficult because it seems to start from the premise that it's not a trust and then reason from that premise the conclusion that it's not a trust, which seems a bit like begging the question. I think, if I might, I'll give a fairer reading, which I think is what Mr. Justice Freedman's saying, is that Section 30...
He's making the same point as I put to you slightly earlier on, that it's using the word trust in the sense of somebody who's under a series of fiduciary obligations. That's what he's making. If he's wrong about that, then...
exactly, yes.
It just depends. This all turns on a very narrow point. And the narrow point is, does trust in paragraph 12 mean trust, or does it potentially mean something else as well?
Well, does it mean trust?
Trust in the classic sense.
Yes. Or does it mean it's in the 33(1) sense? There are clearly two senses.
Does it mean trust in a broad sense? And in your cases, it includes every sort of trust, even trusts where there are no beneficiaries.
Yes. Yes.
No beneficiaries in possession.
Yes.
Okay.
Then Little Roman 3, if Parliament had wished to extend the ambit, it could have done so expressly by incorporating expressly Section 68(17), and it didn't do so. This is an argument from silence, and it cuts both ways, because it could have equally excluded that definition or said in the definitions trust does not include an unadministered estate. I say the argument from silence isn't persuasive because it cuts both ways equally well, and you've heard my point about the starting point actually being that the two statutes should be read consistently, not inconsistently. Then for Ayerst and Livingston, I've dealt with those, I think, so I won't say anything more. And then 5, Best and Curtis, as I say, not as persuasive as one might hope it would be, because it doesn't refer to the relevant statutory provisions. Then at 44 to 46, there's the reasoning based on the wording of the exception within paragraph 12, so does interest in possession help us to construe the rest? I've dealt with that already. And then 47, somewhat compounded reasoning, but the main point, I think, is that the judge is saying that administration is supposed to end before 10 years have expired, so that puts estate beneficiaries in a different position from remaindermen. But as I've explained, actually a PR won't necessarily be in default after 10 years because contingent legacies, etc., contingent liabilities, already contingent legacies. So we don't, this provision protects those who can't protect themselves.
Yeah.
So I think that covers the reasoning in the judgment below, and for all those reasons I say that it was wrong about what trust meant. I'll move on to interest in possession, if I may. So for that, apologies if this seems excessive, but I will go back to paragraph 12 again. We can't look at it too often. Page 49 of the authorities bundle. So a person is not to be regarded as being in adverse possession when the estate is subject to a trust, unless the interest of each of the beneficiaries in the estate is an interest in possession. So interest of each of the beneficiaries I don't think is a problem for me, because Earnshaw and Hartley, it's very clear that beneficial interest includes residuary beneficiaries and unadministered estate. And then what about interest in possession? Did the beneficiaries and unadministered estate have an interest in possession? Well, I say no, because of the classic. Well, no, before I go into the definitions, a few points of fact, because the judge below decided this really on, seemed to decide this on the points of fact. The grant here was issued 23rd of October 2019, so the question is whether immediately after the grant was issued, the beneficiaries, whoever they might have been, all had interests in possession. I say that obviously at the time the grant was issued, the estate couldn't have been fully administered because you need the grant to administer the estate. So there must be some period of time after the grant and before the claim is made when the estate is, for some period at least, unadministered. It doesn't matter how long, there must be some period at least. And given that factual position, I don't actually think that I need to rely on any new facts or anything. Of course, in the court below, I think my clients did try and rely on new facts, and the judge didn't like that, understandably. I don't think I need
This
to.
is that there are 7 beneficiaries, or seven.
Exactly, however many of them might have been, doesn't matter for my purposes, so long as there was a period, however long, between, after the grant, when it wasn't fully administered.
What was the question of fact then being explored? Was it who was actually in physical possession of the property? Because that's not relevant, is it?
No, it's not quite clear to me.
It's whether the beneficiaries have an interest in possession.
I think it might have been being said that by the time of the claim they had interest in possession, but that's not relevant because so long as I can show that at some point in that 10 years they didn't, then I'm okay. So I struggle a little bit with the judge's reasoning on this point, on the facts. But all I say is that we don't need to worry
Can you
about.
just have a quick look at
Yes,
what
of
the
course,
judge did
yeah.
say about this?
Yeah.
Since
So
you're
this is
criticising it.
it's core bundle page 99. So tab 9.
So page 99.
Yes, so paragraphs 49 down to 55, the relevant part. Shall I just let your lordships read that again to yourselves, and I'll read it too. So at the bottom of paragraph 49, Ms. Justice Freedman says, it may be that a correspondingly broad process of reasoning should be adopted. It's the question of who the beneficiaries are, namely those who stand to benefit. He doesn't really decide that, but I think what he's saying is that you have to look at who the beneficiaries are. It's not really clear who the beneficiaries are, and therefore the appellants don't succeed. I don't think we need to worry about that, as I say, because there isn't really any issue of fact that I can see that arises from the fact that a grant was made on a given date and that the estate can't have been fully administered the moment it was issued. So we don't need I think the points that my clients in good faith tried to make, but probably weren't the right points to make. I'm making a different point, and so the reasoning in the court below is not a particular assistance. So if I may, I'll go back to the authorities and the case of Pearson and IRC for an interest.
Your point is just that the interest that they had was not an interest in possession. Is that right?
Exactly. Yes.
So,
Simple as that. Simple as that.
or putting it another way, you can't give the words of the back end of paragraph 12, beneficiaries in the estate have an interest in possession, have some sort of extended meaning.
Yeah.
Along the lines of might or might not have an interest in possession in due course at some stage in the future. I mean, that's essentially your point, isn't it?
It is, yes. Yeah, I possibly could sit down now, but if you'll humour me at least by looking at Pearson. Pearson is tab 13, page 160 of the authorities.
Sorry?
Tab 13, page 160. And in fact, sorry, I'll go straight to 179, which is the relevant part of the judgment. Judgment of Viscount Dillon in the majority. First paragraph here on 179, internal page 772. Excuse me. In Preston Treatise on Estates, an estate in possession is stated to be one which gives a present right of present enjoyment. This was contrasted with an estate in remainder, which it was said gave a right of future enjoyment. Goes on to refer to Fern on contingent remainders, very similar definition. Then further down the page, the marked paragraph at F referred to considerable number of statutes where the phrase is to be found. He's construing the Finance Act 1975, which is now the Inheritance Tax Act 1984. It suffices to say that I saw nothing in them to indicate or suggest. I see nothing in this act to suggest that it has a different meaning. So 2 points to be taken here. First, not so importantly, technical meaning of the IHT Act is present right of present enjoyment. Second, much more importantly, its meaning as a matter of general law, since the early 19th century at least, is present right of present enjoyment. So one would have to see something pretty strong, I think, to infer that that Parliament was intending a different meaning in the 2002 Act. Then, does a beneficiary of an unadministered estate have present right of present enjoyment? Well, no, obviously not. They've got a present right, but it's a right to the due administration of the estate. That right might come into fruition in due course, suppose so long as the creditors' claims aren't too large. In the case of land, it's a right potentially to enjoy that land in due course if it's not sold for the creditors or just sold generally in the course of administration. Worth looking briefly at section 43 of the Administration of Estates Act, which is tab 1, page 8 of the authorities. Subsection 1 here. Yes, page 8 of the authorities bundle. Personal representative, before giving an assent or making a conveyance in favour of any person entitled, may permit that person to take possession of the land. Such possession shall not prejudicially affect the right of the PR to take or resume possession, nor his power to convey the land as if he were in possession, subject to the interests of lessees, etc. So, quite clearly, it's may permit in the second line. It's a power for the personal representative to permit somebody to enjoy estate land during the administration period. It's not a right, a present right of enjoyment. They're the objects of a discretion or power. Same point arises from Williams and Holland. This is Authorities Bundle, tab 10. tab 10, page 112. So this is a case where, to summarise the slightly complicated facts, is the will contains a specific gift of property to 4 children in equal shares. One of them is in possession after death. The executor, who happens to be another of the children, gives the child in possession notice to quit. Child doesn't quit. Executor brings possession claim succeeds. Court of Appeal, Lord Upjohn in the Court of Appeal, at 116 is the relevant passage of the judgment. The last paragraph on that page, beginning with the square bracketed bit. It's in those circumstances, I should mention that there were debts that needed to be paid. In those circumstances, the plaintiff comes to the court, says he desires possession in order to sell the property for the purpose of administration. To that application, there can, it seems to me, be no conceivable answer at all. It's said that he ought to have exercised his power under section 3610 to assent to the property subject to a mortgage to the 4 children entitled, I think that means. But it's quite plain that that is only a power, so that's another power, along with the section 43 power. And if the executor prefers to sell, as he may well in circumstances I have mentioned, no beneficiary can compel him to make an assent subject to the mortgage. Accordingly, over the page, it seems to me that the defence to the action for possession is entirely misconceived. He says he wants vacant possession, he's entitled to it, so they don't have an interest in possession, clearly. Manover's skeleton argument relies on Earnshaw and Hartley to say that one doesn't make artificial distinctions in the law of adverse possession, and that one can sort of look through the administration period in some sense. I say that's wrong. One shouldn't make artificial distinction, but it's not an artificial distinction to distinguish between an interest in possession and one that's not in possession, because as I've shown, that's the distinction between someone who can bring a possession claim and someone who cannot. That's a real and substantial distinction, not an artificial one, and it matches the statutory language of an interest in possession, which is precise terminology with a well-established meaning. It might be said that I'm trying to have my cake and eat it by saying, oh, well, take a loose interpretation of trust and a precise interpretation of interest in possession. But there's a good reason for that, which is that the interpretation of interest in possession, well, there's only one interpretation anyway. I'm not actually being overly precise about it. It's the common law definition that I'm applying. As I say, there is a real and substantial distinction, not an artificial one, between the two types of, between interest in possession and something that's not an interest in possession. There's not a real and substantial distinction for adverse possession purposes between the unadministered estate and the trust. In fact, they're much more like each other. The trust in the narrow sense, that is, they're much more like each other for adverse possession purposes than they are dissimilar. So unless I can assist your lordships further, those are my submissions.
Your submissions apply, you're applying them to all unadministered estates.
I apply them to all unadministered estates where a grant has been taken out. The position is at least where you have an intestate estate, which is the point Lord Justice Zacaroli has been developing. At least where it's intestate, the land on death vests in the public trustee, not in the PR. So it might be that a different position applies there. I don't think I have to be particularly definitive on that because it's not our case, but it does seem to me that there is no trust in those cases because the public trustee, section 9 of the Administration of Estates Act, doesn't hold it subject to duties. They're a kind of totally neutral, just is vested, parked on them, and they don't have to do anything with it.
So there would be no trust in that situation.
Yes, that's my submission.
And in testate estates, what are your submissions in respect of them?
Partly depends on the terms of the will, but assuming that the terms of the will don't oust the statutory trust in section 33, and I think I can't really see how they could. Usually what they do is just reenact it in their own words. In that case, then yes, the trust right to the estate from death because the land vests in the executor on death. The only difference pre and post grant is that the executor can't prove title. So possibly if you're in adverse possession, like Mr. Best was, you apply for registration and no grant has been made, possibly the executor won't be in a position to respond. But I don't think we need to go down that road particularly because it's different from the question of whether there's trust there, which was your lordship's question. Yes, there is a trust there.
What I'm trying to work out is the practical effect of your case in both testate and intestate estates on the potential rights of somebody who's in adverse possession. And as I understand it, your case is in respect of intestate estates. They lose effectively any rights that they would otherwise be acquiring in respect of their adverse possession because a trust comes into existence. Paragraph 12 applies, and they can never effectively exercise. They might have been there for more than 10 years. Is that right?
Yes, so in intestate estates when the grant is
So
made.
all intestate estates, any rights that someone in adverse possession would previously have gone.
Once the grant's made, yes.
And in testate estates,
It's from death.
so from death, they also lose all.
They don't have rights as such. Time was running, but it's not a right.
But I appreciate that. I'm using shorthand. They've been there for more than 10 years. So if they made an application, there would have to be. So you're saying the effect of this is that on death, all rights that would otherwise have accrued in respect of adverse possession go.
That's putting it very widely, but yes, I think
Well, it's a logical consequence of what you're submitting, I think is what my lord's
if there
saying.
is there any, there might be rights that I haven't thought of in the context of. So,
But it's quite a significant provision.
yes.
The consequence of the death of the registered proprietor is that nobody can acquire squatters' rights, putting it that way, under the which they would otherwise be entitled to under the legislation. In other words, applying to be registered as the owner because they've been.
Which they would have had against him if he hadn't died.
Which they would have had against him if he hadn't died.
The same is true, of course, if I settle my land on trust. Anyone who had rights the day before I settle it, let's take the most obvious case is on trust myself then for my daughter, absolutely. The moment I do that, paragraph 12 hits. So that consequence, I say, happens on death or in intestacy on the taking of the grant. I agree it's quite a stark consequence. I think the reason it's quite stark is we saw earlier with the joint report, they were going to do this thing with qualified title. For whatever reason, they decided that didn't work. So instead, they go for this slightly hard-edged provision in paragraph 12. That's a decision that the legislature has made for trusts without interest in possession. And I say that applies without distinction to the unadministered estate.
And in terms of intestacy, it doesn't apply if nobody has taken out a grant.
Yes.
But intestacy it does apply regardless of whether or not the executors have taken probate.
Yes, subject to the possible distinction that I mentioned earlier about needing a grant to prove title if you're an executor and therefore to respond to an application.
I understand that, but paragraph 12 would apply.
Exactly.
So there's an anomaly there.
Executors and administrators, there are differences between the two. It's not necessarily anomalous to regard them as being different. Yeah, there's a difference.
And what would be the reason for that? Why would this actually be framed in that way?
In the context of so adverse possession is really about bringing claims. I can put it that way. It's to do with limitation and claims.
But it is in respect of registered land. It's not so much in respect of unregistered land.
Does your lordship mean the reverse there?
No, because in respect of registered land, you have to bring a claim to be registered.
Yes, I see what you mean. But in unregistered land, you need to have had a claim.
Sorry. Yes, okay.
I don't,
It-
what was your lordship's point? I've
I
confused
don't know,
both
I'm
of us, I
lost.
think.
I thought you were making a point, actually, not me.
Turn this round on you now.
There was
But I can't remember.
it was the difference between the two, executors and administrators. The difference is not surprising. There's a difference because if I'm in intestacy, I can't bring any claims before there's a grant. You know, if I come and sue someone, even if I'm entitled to the grant on intestacy, if I come and sue somebody, then my claim's going to be dismissed because I don't have title to sue. I'm in a different position from the executor in that respect. The executor does have title to sue from the date of death. He will need a grant of probate by the time he gets to the trial, but he can issue a
Can
claim.
actually commence proceedings for possession.
He can commence, exactly, yes. In fact, I don't think it matters here, but you might have seen that there was a previous claim brought by my clients. My understanding from reading the papers is that failed because they didn't have a grant at that time. So that there is quite commonly a difference between the two things. It's not surprising, it's not anomalous.
Can I just ask you about Williams and Holland, which you were on? You may still have it open, I don't know.
Yeah.
The top of page 117 of the bundle. So this is Lord Upjohn explaining why the claim for possession must succeed. He says, third line, the executor as such is administering the estate. There has been no assent. The trust for sale has not yet arisen. What do you mean by that? What trust is he referring to?
I wondered that myself when I was reading it. I think what he means is the trust for sale that used to exist under the 1925 Law of Property Act for co-owned property, because this is it's a gift to full co-owners as beneficial tenants in common. Before Talata, such a gift post-assent, he would have sent it to the full beneficiaries to hold on trust for themselves as tenants in common. The type of trust that would have arisen would have been a trust for sale.
Because at the time of this decision, section 33, I think, referred to trust for sale, didn't it?
Creates a different type of trust for sale from the co-ownership trust for sale, yes.
But since he's talking about the position of an executor,
Yes.
might have thought that he was referring to the trust for sale under the Administration of Estates Act.
He can't be in my submission because, we've seen under 33(1 as it currently is, the trust bites from the beginning. It doesn't bite from the end because by that stage you've paid all the debts, etc. So he must be referring to the trust for sale, the co-ownership trust for sale. It is an extemporary judgment.
Thank you very much indeed.
Your Lordships, I see the time, and I wonder if it would be preferable for me to start after the short adjournment.
We'll crack on till 1 o'clock.
Well, may I also repeat that request because there is a specific point that has occurred to me during the course of this morning, arising from some of the materials, which I haven't raised with Moylan previously. And I would rather like to offer him the chance to knock my suggestion back.
We'll come back at 1:45 in that case.
I'm very grateful.
Court rise.